Hello, everybody. Welcome to our webinar today, Estate Planning, what it is, why it's essential. And we will be starting in just about 1 minute. I just wanted to pop on here and say welcome to everyone and see if you can hear me. So if anybody is out there and has access to the comments, I see some people are in the chat already. Just let me know that you can hear me and see me. Should be able to see me and part of your screen, and then there's going to be a slide with some information on the other part of the screen saying estate planning, what it is, why it's essential. Great. All right. So here we go. It is a wonderful day here in Wisconsin, and my name is Dan Kraus. I want to welcome you to this webinar. We are going to be talking about estate planning. We're going to be focusing on Wisconsin. I am an attorney licensed in the state of Wisconsin. I am also licensed in a couple of other states, but I mainly practice in Wisconsin. Most of the things that we're going to be talking about today will apply in any state of the United States. However, they may not apply in a state other than Wisconsin. I'll try to mention if I know if there's certain things that are Wisconsin specific, but otherwise, just sit back, enjoy, and hopefully learn a little bit of something. All right. So estate planning, what it is, why it's essential. My name is Dan Kraus. Like I said, I'm an attorney. I practice law in Wisconsin. I'm a former military member. I was a JAG officer, and before that, I was a medic in the U.S. Army. I spent most of my time in the Army Reserves, though I served in the active Army for a little over 4 years, and also in the National Guard here in Wisconsin for about 4 years out of my total 21 years of service. I also served in the Peace Corps for a couple of years. I wrote a book, Estate Planning in Wisconsin. It's available on Amazon if you'd like to purchase it. And I've been doing this for a while, about 25 years, 24, and I am a certified estate planning law specialist. There are 7 of us specialists in Wisconsin. Very proud to have that specialty designation. Here's a copy of the book, Estate Planning in Wisconsin, Privacy, Protection, and Taking Control. And we have a lot of memberships and affiliations. Our firm focuses on estate planning and estate administration. So that means helping people plan for the inevitable when they pass away, but also helping them plan for what happens if they need to go into a nursing home, or what happens if they become incapacitated and someone else needs to take over and make decisions for them. Also, we help people deal with the aftermath of a death, or somebody becoming incapacitated, or someone needing nursing home. We also deal with that. So our memberships and affiliations are very concentrated in these areas of the law. So first of all, what is estate planning? Well, estate planning is getting your stuff ready so that in case you become incapacitated or if you pass away, that your affairs are in order. Some people call it getting your ducks in a row, but it's legal planning in order to make sure things go as though you want them to. Some of the aims of estate planning are to minimize the amount of work that needs to be done if someone does pass away, to minimize the taxes that have to be paid upon transfer of wealth or upon just passing away, as well as minimize the amount that a person would have to pay for their care if they should go into a nursing home or assisted living facility. So a comprehensive estate plan really has 3 very important, essential elements. They are 3 legal documents that need to be signed, and they need to be signed in a specific way. And they must be signed by a person who is at least 18 years of age is competent, meaning they have their mental capacities, uh, enough mental capacities so they know certain things about what they're signing, and they have to be signed sometimes with witnesses, sometimes with the notary public. It depends. There's different rules, but the three basic documents of a comprehensive estate plan are the will, the power of attorney, and then the healthcare power of attorney. So financial power of attorney, healthcare power of attorney, very different things. Each of them controls different aspects of a person's life. But those two things are things that can control your assets and your protection and your healthcare when you are alive. And the will takes over when you have passed away. So let's talk about powers of attorney, healthcare and finances. So a healthcare power of attorney is the most common estate planning tool. When clients come to me or potential clients come to me and they say, well, I have done some estate planning. I have a healthcare power of attorney or an advanced medical directive. And the reason that this is the most common is because when people go into the hospital or maybe they're getting ready for surgery, oftentimes the medical people insist that the person sign one of these just in case something happens and they need someone else to make a decision for the person who is going into surgery or receiving medical care. It allows someone else to make your healthcare decisions for you. It allows someone else also to decide to stop medical care or pull the plug, as they say. It can also allow for organ donation, uh, but one of the most important things it does is it avoids a guardianship proceeding, or it helps to avoid a guardianship proceeding. If someone has the ability to make the decisions for you, there's no need for a court to appoint somebody to make those decisions. So if you have that document, someone can make the medical decisions for you, including pulling the plug, but sometimes as as uh, as everyday decisions like where are you going to live, who gets to visit you, and things like that. That's all the healthcare power of attorney. So essentially, it's control of the body of the person, not their finances. So financial power of attorney, some people call it a general durable power of attorney. General and durable are different, specifies what the power of attorney allows somebody to do. Financial power of attorney, when you call it a financial, it distinguishes it from the healthcare power of attorney. So a general power of attorney is a power of attorney that is meant to cover everything financial, everything financial. Durable power of attorney means that if you become incapacitated, the power of attorney does not end. So durable just means it goes until death or until the person revokes it on their own. And general means that it's supposed to cover essentially everything that that person can do financially. The other person that is given the power of attorney can do that for them. Now, state laws vary greatly on these aspects. I really know a little bit about Minnesota, Iowa, some about Nebraska, but the Wisconsin laws are the ones I'm most familiar with. I really like the Wisconsin laws having to do with financial powers of attorney. It makes them so that a financial institution is not allowed to refuse to accept the power of attorney, except for in very limited circumstances. Now, most states that I've studied or looked into, the bank or another institution may have the right to just refuse powers of attorney just because they don't like them. Not for any legal reason. It's just that they don't feel like accepting the power of attorney. In Wisconsin, we do have good laws that make it mandatory that a power of attorney is accepted. And if the person still refuses to accept it, then the law allows you to sue them to accept the power of attorney, and then they have to pay your legal fees for that. Beware downloaded forms. A downloaded form is better than nothing, usually, but it sometimes is false security. If you think you're covered by a downloaded form, even the one that comes from the state of Wisconsin, from the Department of Health Services, they are limited. They're limited powers of attorney. It may say general power of attorney. You may initial every part of that power of attorney so that you think it covers you in every situation. But the law is very clear that that power of attorney does not cover everything unless you have specified it. So that's why you really need to get a power of attorney from someone who knows what they're doing in order to make sure that you are covered in every situation. Most importantly, the situation where a loved one needs to try to shuffle your things around in order to save your assets from nursing care. This financial power of attorney is so important if one of your loved ones is trying to help you save your house or your other assets from the spend down and recovery that comes with needing Medicaid to pay for nursing care. Okay. Also, please don't just give anyone your power of attorney power. The agent is the person that you appoint to be able to do stuff for you. Don't just give it to anybody, especially if somebody asks you. If they say, I really think you need to appoint me as the power of attorney, you should take that with a grain of salt, because my experience shows that the person who is eager to do this job is usually not the right one to do the job. It's a person who wants control, and maybe it's going to cause you some heartache, or your heirs, or if it's one of your children, it's going to cause the others to start fighting. Okay, so if you don't plan for incapacity, meaning you haven't done these healthcare and financial powers of attorney, or if you've done them wrong, or if you've used the wrong form, then the state law is going to control, which means if you don't, or if nobody has the power to make the decisions necessary to either keep your health care going or to keep your finances going, then there's going to need to be a guardianship. So when a person is unable to make decisions for themselves, they are not legally competent to do that, and they have not given someone power of attorney so that that person can step in and do that for them, then everyone needs to go before the judge. It has to be proven that they are incompetent, and then the judge steps in if everything's proven and takes away all of that person's human rights. Not all of the human rights. You can't torture the person, but it takes away their rights to contract. It takes away that person's right to marry or divorce. It takes away the person's right to have a fishing license, a hunting license, a driver's license. It takes away that person's right to make healthcare decisions for themselves, to decide where they're going to live. It takes away all of these rights, all of these human rights that you have as a person if you go into guardianship court. So that should be avoided at all costs. Also, you might get a guardian that you wouldn't want. You might get a guardian that is more interested in what they can get for themselves than what they can do for you. You just have to be careful. So you don't get to pick because you are incapacitated by that time. So before you get to be incapacitated, while you still have your right mind about you, do these documents so that you can avoid a probate court. The probate court is where they do guardianships. All right, so after death, what happens if you don't have a will? A person who doesn't have a will that dies is called intestate, and all it means is that they didn't have a will. In means non or not. Intestate just means a testament, so they didn't have a last will and testament when they died. No plan. So the state law, once again, the state law controls. If you don't have a plan, the state's got one for you, but it's probably not the one that you would choose for yourself. So if you are intestate when you die, the state law controls. Generally, your closest relatives get it. Now, in some rare cases where a person doesn't have any relatives closer than a first cousin or a second cousin, closer than a second cousin, the state gets it. Some people mistakenly think that if you don't have a will, the state gets your property. It's rare that happens because they will find close relatives to you. Sometimes what we call laughing relatives is people that find out that you died. They don't know you, but they inherit from you, so they're laughing instead of crying. That could be first cousins once removed, twice removed, etc. So that could be a problem. Your relatives will have to go through probate court in order to get control of your assets and distribute them. That's a hassle. 18-year-olds with money. So imagine that you don't have a will, but you think, oh, my kids will just get it. If you have kids who are under the age of 18, they will just be handed whatever money that they're going to get at the age of 18. And the law requires that to happen. So then they're just probably, if they're like most 18-year-olds, just going to blow it, or somebody's going to talk them out of it, or they're going to, get married and get divorced within a year, and it's all going to be gone. In a second marriage situation, if you die without a will, imagine that you have children, maybe in a first marriage, and then you get married again in the second marriage. If you don't have a will there, that is just asking for all kinds of havoc for your surviving partner and your children. So once again, intestacy, a little story about intestacy. James Dean, some people know him. It's an older example, but I think a lot of my clients and potential clients remember, or they've heard the story. James Dean died at 24. He was a famous movie actor, rebel without a cause, made movies in the 1950s. He died at 24 from a car accident. And he didn't have a will. Well, that's not surprising. Most 24-year-olds don't have a will. But in his case, it really affected how things happened, different than what he probably would have wanted. Of course, we don't know because we can't ask him. However, his entire estate passed to his father. His mother had died when he was a young man, about 8 years old, I believe. And at that point, his father essentially abandoned him to his mother's sister. So his aunt raised him. They were close. They had a good relationship. But then when he died, the aunt was not the closest relative. He did not have a will. So his father got everything. The aunt was left out in the cold. And James Dean really didn't like his father, at least at the time that he passed away. So what are some pitfalls of having a will? So it's better to have a will than to not have a will. But the will is still can create some problems. When you have a will after your death, if the will is going to control your assets, you have to have a probate case, which is a court case. So that means the will cannot be effectuated without the court having a court case, opening up the case. The court has to investigate whether the will is accurate, and then it has to appoint the person who's going to administer the estate. And then the court kind of supervises and makes sure all of the steps have to be done. It usually takes over a year for a probate court case to start and then finish everything. With a will and a probate court, there's no privacy for the loved ones because anything that goes through the court is a public forum. All of your documents, your assets, your children's inheritance all gets displayed for anyone who wants to look at it, which in turn invites predators. So as we know, data mining is a big thing these days, and it's getting more and more and more and more invasive. They have chat bots and bots out there that are combing public records. They're combing probate records. They're combing any kind of records. And what are they looking for? Money. So as soon as they find out your heirs are inheriting, they find out how much they're inheriting, they're going to target your heirs for some sort of get rich quick scheme. It could be targeted for marriage proposal, things like that. You never know if everything is public, why people do what they do. So The other option besides having a will control everything in your estate is to do trust. Many people have discovered the wonders of the revocable living trust. It is a will substitute, among other things, and it does not have to go through the probate court. It stays private. There's no public filings. There's nobody that can get in and pry in to see what your children are getting. And it goes faster because it's done over the kitchen table by your kids instead of across the judge's bench by somebody or an attorney that you may not know. All right, so let's talk about trust. A revocable trust. Now, there's hundreds of kinds of trust. People use them for different kinds of things. The revocable living trust, or the revocable trust, is a will substitute. It's mostly used to plan for how things are going to be distributed after a person dies. It avoids probate, preserves privacy, and it is controlled by you. And after you die, it's controlled by the person or people that you put in charge as the successor trustee. So you could name any number of people to be successor trustees. You can name them first this one, then that one, then that one, or you could name them to serve as co-trustees so that you can have more than one at the same time doing things. Irrevocable trusts can serve the purpose of transferring assets at your death, but the main purpose is to usually preserve assets during your lifetime from lawsuits or divorces, or most commonly in my practice, from spending on nursing care. There's also irrevocable trusts that their main purpose is to save taxes by having charitable beneficiaries. So you get a tax benefit from putting money into one of these irrevocable trusts, and then at your death, the charity gets it. So different types of trusts are used for different things. You may have heard of a special needs trust or a supplemental needs trust. That is to protect the assets of a disabled person. The reason that disabled people should not inherit directly, usually, is because those disabled people oftentimes rely on public benefits like SSI, Medicaid to pay their costs of their health care, etc. And if they inherit a chunk of money, they're going to lose those benefits because the benefits depend on them having a low amount of money. Sometimes when you give money to an heir, like a child, it can get lost in the child's divorce, or if that child has a lawsuit against them, or if that child goes bankrupt. Your money that you gave them could be lost. So we do also have trusts to protect that money, so that instead of just giving the cash to your child, you could give them a trust with the cash inside it. And now they get to control that, and they are able to use that for their benefit without having to worry about losing it in a divorce or a lawsuit or bankruptcy. We can also do perpetual trusts. Those are a little more rare because most people don't really have a plan for what's going to happen in their family 3, 4, 5 generations down the line. And it is something that you really have to anticipate what all the problems might be, but you can create a perpetual trust, and some people do, say with a cabin up north, or with a certain amount of money that's just going to generate income for generations. There are multiple methods of transferring assets upon your death. We've talked about wills, we've talked about trust. There are also ways that you can put beneficiaries on your property. You can make your property into a co-owned thing with your children. So you put them on as a co-owner or a joint owner with rights of survivorship. Some of those things have real risks to them. By putting someone on as a co-owner, it makes so that if they get divorced, now your assets get dragged into their divorce. If you put on pay on death or transfer on death beneficiary on them, it's not certain that those assets are actually going to get to where you want them to be, especially if something happens to that person during your lifetime, or if you're in the same car, etc. So the best and the most secure way of making sure that your wishes are taken care of after you die is, in this case, a living trust. Let's talk a little bit about the estate tax. Now, the estate tax in Wisconsin is only a federal estate tax because Wisconsin does not have a state estate tax. So Wisconsin doesn't have an estate tax. Many states do. Wisconsin used to have an estate tax, but in 2008, it was essentially abolished. So now all we have to worry about is the federal estate tax. Currently, you don't pay any estate tax unless your taxable estate is over $3.61 million. Now that's indexed for inflation, so it goes up every year. However, next year is the last year it's going to go up unless Congress acts and the president signs a new law. That law that gives the really high exemption is going to be cut in about in half. And we should have about a $7 million exemption in 2026. So at the end of 2025, the current law sunsets and we go back to the background law, and that's going to be about $7 million. Now, even with that lower threshold, still less than 1% of the population is going to have to worry about an estate tax. That's why we're not going to spend a whole lot of time on this, because so few people need to worry about it. If you're one of those people, I'd be happy to talk with you about that in detail, just so that you know the things that are included in your taxable estate include your life insurance, any IRAs or 401ks that you have, all of your real estate, all of your bank accounts, etc. Those are all, you add them all together, and then you see what the amount is. If it's over $13.61 million, then it gets taxed at 40% on everything above that amount. So what more people have to worry about is typically nursing home expenses. So taxes are not the big worry for most of the population. It is the nursing home expenses. And if a person reaches the age of 65, they are about 50% likely to spend some time in a long-term care facility. So that's why we're going to concentrate a little bit on that and talk to you and explain that there are things that can be done to save your family's wealth instead of watching it go down the nursing path. So the things that we do, we break up into two categories: pre-planning and crisis planning. Pre-planning is when a person, during the time that they're healthy, takes their assets and moves them in different ways in order to get them out of their countable assets, so that they can save the assets that they put aside, and then they do not have to spend those assets on their care, or they and their family can choose whether to spend those assets. That's more accurate. They could spend the assets if they wanted. We use Medicaid Asset Protection Trusts, or MAPT, to take assets like a house, like the cabin up north, maybe some of the stocks and bonds, but not the retirement accounts. IRAs and 401ks cannot go in here. We take the real estate and things and we put them in an MAPT. We put the kids in charge of that, and then they just hold on to it. If mom and dad need it for their security or they want to get it back, then the kids cooperate with them and give the assets back to mom and dad. Therefore, now they have a choice. Do we want to spend our money? Do we want to take it out of that MAPT and spend it on our care? Or do we want to leave it in the MAPT and take advantage of Medicaid to pay the long-term care expenses? That's pre-planning. Now, crisis planning is when somebody's in a nursing home or is about to go in a nursing home and we need to save their assets quickly. Typically, the amount that we can save in a crisis is much less than the amount that we can save by pre-planning, but we can still save a great deal of the assets. In fact, I just got a plan back from for one particular client where we were able to save about 2/3 of their assets, and the other third just has to be spent on their care until the Medicaid will kick in. So some people say, well, this all sounds like it might be cheating. If a person arranges their assets in a certain way so that they can take advantage of certain government benefits, that sounds like it's cheating. Certainly the government doesn't want you to do that, do they? Well, I've got an answer to that, and I have no qualms about helping people do this because in our country, there is what we call discrimination. Now, I'm not talking about racial discrimination or discrimination based on gender or sexual preference or anything like that. I'm talking about discrimination based on disease. Now, there's no law against that, and the government engages in it every day. Disease discrimination works like this. If a person is in their old age and they happen to get cancer, their payments come from Medicare. Cancer payments can go into the millions of dollars, and they don't have to pull out of their pocket. They don't have to go broke in order to get those payments. Cancer patients don't have to go broke. On the other hand, if a person gets Alzheimer's disease or some other ailment that puts them in a nursing home instead of cancer treatment or heart treatment in the hospital, now, for whatever reason, they now have to go broke and they have to pay out of their pocket and pay and pay and pay until they have nothing left. So I wouldn't want to call a cancer sufferer lucky, but compared to an Alzheimer's sufferer, financially, they're very lucky because cancer patients get their care paid for through health insurance and Medicare. Alzheimer's sufferers have to have long-term care, which will not be paid for even 1 penny from Medicare or their regular insurance. So the government has a plan for you. Like I said, if you don't have a plan for yourself, the government's got one for you. And let's talk about what's the government's plan if you need long-term care. Well, the government's plan is you just take all of your assets, you sell everything and spend it down until you have nothing left but $2,000. You can keep your home and you can keep one car. Even if you're a couple, you're only allowed one car. And that car can be of any value. It can be a high value car, doesn't matter. And then you can keep burial insurance plus your household goods and furnishing. So the pots and pans and the furniture, all of those things you can keep. Now, a lot of people say, great, hey, most of my value of my assets, my legacy, let's say, is in the house. So bought this house, we'll just keep it. If we need to go on Medicaid, we can keep the house and still not have to spend that money. We don't have to sell the house to pay for our care. That's a great idea, except the other part of the government's plan is called estate recovery. And what that does is it comes and takes the house to repay any Medicaid that was used. So if a person's on Medicaid, they keep a tab, the government keeps a tab and says, this is how much was spent during your lifetime. And they present the tab after your death and they take your house and anything else that you might have at your death. So that's the government's plan. What's your plan? Your plan should be to keep the assets for the kids, the house, the farm, the business, or to at least keep the assets for your own security during your lifetime. And then if you pass away, the kids get that. So I just want to emphasize, one size does not fit all. Everybody has a different situation. If you're a couple, the calculations are much different than they are if you're a widow or a single person that needs this type of care. It's important that you know all the rules, which we can't really go over at this time. There's just not enough time. But it's important to know that if you know the rules, which we do, you can use the rules to your advantage instead of to the advantage of the government, instead of to the advantage of the nursing facilities. We use the rules to our client's advantage. Now, there's nothing wrong with using the rules to your advantage, but I do want to tell you, if you go and ask your nursing facility, if you go and ask the ADRC, if you know what that is, that's the Aging and Disability Resource Center. Wonderful place, gives great advice about Medicaid, but it doesn't give great advice about what you should do in order to qualify for Medicaid without spending everything. If you ask the nursing home, if you ask the ADRC, if you ask the county, they will all tell you, you just need to spend everything down. And then as soon as it's all gone, then you come back to them and they will help you to qualify for Medicaid. I'm telling you, there are ways. You don't ask those people, you ask somebody who's got your best interest in mind, your family's best interest in mind, instead of the county's best interest or the nursing facility's best interest, so that your family can take advantage of the rules instead of having the rules take advantage of them. All right. So also with general estate planning, just deciding how you're going to divide up your estate, especially in cases where you have second marriages and he's got kids and she's got kids and maybe they've got one or two together as well. Those are very complicated. Sometimes a person comes in to see us and they have a high net worth. We deal with them much differently than we deal with a person that has more median type net worth, because we have to be worried about more about taxes for the high net worth people, worry more about the nursing home care for the low net worth people. Younger people with young children have different things to worry about than older people who have grown children. There's a lot of things that need to be taken into account, whereas if you pull down an online form, they're not going to be properly taking account of your situation. They are just standardized forms. You fill them out and it's not specific to you or your situation. Be careful about the one size fits all standardized forms. Some other things that can have an effect on how you should do your planning, whether you're a veteran or non-veteran, whether you're older versus younger, etc. Also, different states are marital property states. Wisconsin is one of 11 marital property states where marital property is recognized. The rest of them, the majority of states, are not marital property states. So you have to plan differently in those states. So if I can't do this myself, or if it's dangerous, you can always do it yourself. And in fact, I've made a lot of money helping families clean up the messes that people have made for themselves. So if somebody dies and they've done their own planning, that's usually a good thing for me, because we also do the estate administration and it usually costs a lot more than if the person had done the proper planning. So the bottom line is, choose an experienced guide. You don't have to come to us. We are an experienced guide, but if you know somebody that does estate planning law, now, I'm not talking about somebody that will do a divorce and a bankruptcy, and they'll do some other things for you. Maybe they'll help you to buy your home, things like that. But they'll also write a will for you. Beware. They're not specialists. They're not somebody that does this all the time, and they're probably not using the proper forms and asking all the proper questions. If you would like to take advantage of a free consultation, if you are in Wisconsin or if your relative who you want to help plan is in Wisconsin, we're happy to do a free consultation. Um, we've got offices in Brookfield and Madison and Oregon, Wisconsin. You could come in and make an appointment, or we can do, if you're further out, we can do appointments through the video like this, where I can see you, you can see me, we can share information. I can make some recommendations and I can give you a quote. So that's how it works. We do all of our planning on a flat fee basis. If you need some planning, we will take a look at your situation and give you a flat fee quote. That's what it's going to cost. We don't do this on an hourly basis. We don't want people to have to worry how many hours are they going to work on it? How long is this going to take? It's like a black hole. I just keep getting bills and bills. We will tell you right up front, this is the cost and this is how we do it. If you want to make an appointment, please just give us a call right now. You could go also to estateplanningpeople.com. We're happy to make an appointment for you. Just go through the process. Typically, when you call, it takes about 6 to 8 weeks by the time you've got all your documents signed and notarized and all legal. Now, at this point, I will take any questions and try to answer questions if anybody has them. So I'm going to look in the chat and see what we've got. All right. I see 2 questions. Laura has been flagging them for me. So let's see. Should you add your children as owners of your home for tax purposes? That is a big no. You should not add children to the ownership of your home for tax purposes. There's no tax advantage to adding your children to the home. There are other disadvantages, like if your child gets divorced or dies on you, now your home is going to transfer to their heirs or to their ex-spouse, and you really definitely don't want to do that. So please don't do that. I don't know your exact situation, so there may be other factors that I'm not considering, but in general, putting your child's name as an owner of your home, not a good idea. It's dangerous. You may lose out on tax advantages. In fact, it may be a negative tax advantage or a tax penalty for you to put them on as an owner. You'd have to discuss that one-on-one depending on your situation. General rule, don't do it. All right. Let's see. What do you know about the legacy assurance plans? I'm not sure. There are a lot of people peddling a lot of different plans with a lot of different names, and they all sound really great. Legacy assurance plan sounds like it's some sort of insurance. I don't know. Other estate planners may have some branded way that they call their, whatever they're doing in planning. I don't know what that legacy assurance plan is. If it's something that is created through, say, like a financial advisor, beware. They're practicing the unauthorized practice of law. They don't have professional liability insurance. They don't have an attorney that's going to help you. Be careful. Be careful about all these LegalZoom and documents online and these financial planners that don't have legal experience or training trying to give people estate plans. They're just looking for another way to bring people in and take their money without giving them a quality product. Please be careful. And like I say, if you want a second opinion or a first opinion, you want to talk to me, you want to talk to somebody in my office, another attorney, it doesn't cost anything to come in and talk about this stuff. So I'll be happy to talk with you. Make an appointment. All right, let's see. Do you deal with long-term care plans? I don't sell them. I think they're a great idea, especially for somebody that bought them 20 years ago. People who have long-term care plans that they got in the 90s or the 80s should never let them lapse. The ones that you can get nowadays, the premiums are higher, the benefits are lower, but still you have to look at your cost benefit analysis. Long-term care plans can be good. They can be a great way to make sure that you don't lose your assets in case of nursing care, but you have to look at the cost and the benefits. So you'd have to price out the plans and see whether they're for you. Long-term care insurance is very difficult to get after you're, say, 65 or so. If you're much younger than that and you've had like a health scare, they can also be impossible to get because they look at your health history. They actually, a lot of times, they send a nurse out to do some blood work on you and check your vitals and weigh you and everything. And then they put it into their calculator and they come out with either we can give you a plan and here's the price. Could be high, could be low, could be reasonable. But if you have a long-term care plan, it's generally a good thing. If you don't have one, you should look into it and decide on your own whether it makes sense. They can be very expensive. Is having a transfer on death deed a good idea if the house is your only asset? So a transfer on death deed can, although it won't always, protect your asset from probate. The reason that it might not protect your asset from probate is if the person who is the death beneficiary is in the car with you and you both go over the cliff and you both pass away. Now you've got a probate anyway. Transfer on death deeds do not allow for alternates and second alternates and third alternates the way that a trust would. But also I want to emphasize that a transfer on death deed does not do any kind of protection regarding nursing care. If you need nursing care at some point down the line, your house may be subject to seizure by the state after you've passed away, even though it does have a transfer on death deed on it. Okay. Can a married couple without children benefit from an irrevocable trust? Married couple without children. So it's unusual that a married couple without children would want an irrevocable trust, but it really depends on what their aims are. It's like I say, it's unusual. I can't say in a particular situation. It's not unheard of for a married couple without children to want an irrevocable trust, but it's less likely that they're concerned about leaving a whole lot behind for their children or for the people that they want to get their assets. Usually, my experience is unmarried couples without children would prefer to use their assets for their own benefit during their lifetime, even if it means spending down to nothing for their own care. Also, another issue with married couples without children is that who are you going to trust to put in the hands or in control of those assets? So, as I mentioned before, and maybe I didn't emphasize this enough, is that if you use one of these irrevocable trusts that we call an MAPT, the Medicaid Asset Protection Trust, if you use one of them, that right now when you create it, you have to turn over control to someone. Normally it's your children. Married couples without children usually don't have a person that's close enough and trusted enough and young enough to know that that person is going to be around and be trusted for your whole life until you die. That's another big issue for married couples without children. So that's not every couple, and I don't know your particular situation, but those are just some of the things that I've experienced in my practice. Is anyone in our office licensed in Michigan? No, we're not. We're not licensed in Michigan, just Iowa, Illinois, Pennsylvania, actually, and Wisconsin. Did I say Iowa? I didn't mean Iowa. I meant Minnesota, Illinois, Wisconsin, and Pennsylvania. That's where we're licensed currently. My grandfather has appointed me as an executor of his will and financial power of attorney. He has some money or stocks accounts and has listed his heirs to split this 3 ways. I'm wondering if he did do this, will that money be subject to probate? Oh, if he did do this, will that money be subject to probate? So let's see, he's listed his heirs to split this 3 ways. Well, depends on where he listed it. If he put a death beneficiary on the assets, then as long as those people survive and they are not disabled when he dies, then it will probably go to them without having that money subject to probate. So yes, if you've got an IRA or 401k or life insurance policy and you properly designate beneficiaries on those, they will not go through the probate process. Hope that answers your question. All right. I don't see any further questions, and be happy to hang out for another couple of minutes. I do want to invite you once again, make an appointment. I'd be happy to talk with you about your situation. One question that I'm always asked, and sometimes people are just a little hesitant to ask, is what does it cost to do estate planning? And the answer to that is it depends. Unfortunately, I can't give you a quote right here, but if you want to do estate planning with our office, it's going to start at around $2,500 to do a full comprehensive plan. And estate plans that we do can go upwards of $15,000, depending on how much protection you want, how much tax advantages that you want, and how many people are involved. There are other factors, but those are the biggest ones. What kind of protection do you want? What kind of assurances do you want? And what do you need to do with your assets after you've passed away? We will give you a quote at your appointment, and then you can tell whether it will be worth it for you to go forward or not. Also, if you or a loved one is in the situation where you're in a nursing home or in assisted living and you're spending down your assets, things are just dwindling away, it may not be too late to save something. So that's something where the sooner the better, because every month there goes another $13,000 if you're in a nursing home. Okay. Thank you, everyone. I really appreciate the people who, repeat the average cost range again. So I don't know what the average is, but the low cost range is about $2,500. The high cost range can be, it can be $15,000 or more. There are several things that we do with business owners that we can do multiple LLCs and multiple trusts and things like that can cost a lot of money. For the normal person, though, we're looking at for a revocable trust-based planning right around $5-6 grand. So if you're looking for a revocable living trust, it's going to do all the things that a revocable living trust should do. Come and talk to us. We'll give you a quote, and we can move on from there. Thanks, everyone. I do appreciate your attention, and have a great day. I wish you the best.